But Bruno, as we talk about sale, I do want to step away from the RDP housing conversation. Thank you for allowing us so much time to talk about it. I think it's such a crucial conversation to have. But if we talk about property that's owned in a company or closed corporation, which I hope everybody now converted their CCs to companies by now, but say for instance a company or a CC, even a trust, but specifically companies, if you transfer, does it make more sense to buy the company? What's the logical, practical suggestion around these things and everything else that you've obviously picked up in your firm around this?
Yeah. So sales is quite a funny thing. So a couple of years ago, some genius realized that when transferring property, SARS likes to charge transfer duty. So they decided that if they didn't transfer the property, but rather they transferred the shares in a company. So there were two components, or three rather: the members' interest in a closed corporation, the shares in a company, or they changed the beneficiaries of a trust. They would effectively allow the property to continue sitting in whatever entity it's sat on, but the people benefiting from this, or the people having ultimate ownership in the bigger scheme of things, would change, right? And no transfer duty would be payable because it's a different process than a property transfer, and at that stage didn't fall within the ambit of the Transfer Duty Act. Now, not now, it's been a while now, so SARS picked this up naturally, and they made changes to the laws as they do. And that's actually kind of the funny thing is loopholes with SARS, guys. If it's an unintentional loophole, SARS will fix it. There's even been court cases where retrospectively they change what the intention was, and people have had to retrospectively go back and pay tax on things. So for thinking that poor wording on SARS's part works to your advantage, unlikely. The only time that it kind of makes sense when we speak of loopholes aren't actually loopholes. It's when Treasury decides that something's good for the economy or whatever, and they put it out there, and you utilizing it in a smart way, that's okay. So there's a big sorry, I keep getting full, even though my do not disturb is on. Yeah, so where was I? Yeah, so SARS loopholes. So just be careful, right? Sometimes we think we're smart, but we're really not being smart. Things are there designed for a specific reason. And SARS has quite a lot of powers to rectify situations. Anyway, so SARS ended that, and basically what they said is any effective change, I mean, I'm paraphrasing, but any effective change of ownership. So if new shareholders come in over a company, as an example, if new beneficiaries, substantial change in beneficiaries, there's a change in closed corporation members, that sort of thing. If that happens, transfer duty will be charged on residential property companies. So there's a definition. It has to be a residential property company. That's a company where more than 50% of the assets they own comprise of residential property. In that case, transfer duty would apply. So trying to escape transfer duty, big no-no. So now the second part, so that's the tax component. So should I buy a property or shares in the company? Well, you can do both. You're going to pay the same amount ultimately at the end of the day from a transfer duty perspective. If it's a commercial property and somehow, this company isn't VAT registered, they're different story. There might make more sense to buy the shares than buy the property, because now you're just transferring shares, commercial assets, right? So that's one component, the VAT side. Now, is it a good idea to buy the property outright or to buy the sale of the shares in the company? So now remember one thing. So for starters, let's have a conversation around closed corporations and companies, and then I'll wrap up trust right at the end. So closed corporations and companies. If you buy the business, if you buy the company, or you buy the assets in the company, two very, very different things. You buy an asset, you buy the asset. It's your asset. You can do with it as you please. You don't buy any debt in relation to the asset. The asset, if it's released to you, it's released to you. Simple as that. When it comes to shares, you're buying shares in a company. The problem is in that format, you're taking over ownership of a company that already might have liabilities. So yes, it's got assets, but it's got liabilities. And the downside with this is if you don't know what these liabilities are, you're going to get yourself into trouble. And I'm doing a case now, tax case, where the guy bought shares in a great company. Like the books were wonderful, they were audited, everything was great, only for SARS to open up the books again and decide to audit now a couple of years past. So I think they went back like 5 years or 6 years, and they found income there that, or I don't remember what the story was. Either it was some deduction that was made that shouldn't have been made, but whatever the case is, now all of a sudden there's a 2 million rand tax liability, right? And that happens relatively easy, especially the bigger the company is. And remember, you can buy a company with a very small asset, but you don't know what this company's been doing, and there's no way to trace it. That's the problem with due diligence on company shares. It's very, very difficult to trace because some debt just happens. There's no central database of debt that you can go to, click and go, oh, what debt exists? Sure, a couple of due diligences that one can perform is, have the financials audited against the bank account. So an accounting due diligence, a legal due diligence, also double checking that all the shares were moved properly and there's no weird shares lying somewhere that they don't belong. And then obviously like your credit due diligence, which is check if these things, if there's judgments, if there's anything on the internet, like regarding, how this company trades or whatever the case is. That's not always possible, but on the bigger transactions that I deal with, it has to be done because in those big transactions, you buy shares, right? You also want to take indemnities from the previous shareholders or directors or whatever the case is. That gives you a form of security sometimes. But that's the risk of buying shares and members' interests. Trusts, arguably, you shouldn't actually be able to change the beneficiaries of a trust like that because it defeats the purpose and intention of a trust. So although it can be done and you can amend a trust deed, there's actual argument in our law to say, especially some of our trust deeds and the way that they drafted, where, for example, it speaks of a beneficiary that hasn't even been born yet. So there's this weird argument to say, well, now the intention was to benefit this person who hasn't been born or hasn't come to the age of being able to benefit, but now you're changing all the beneficiaries in the trust. That guy's going to have a claim where he's going to come back and say, well, technically I'm a trust because at that stage, I would have fallen within the ambit of beneficiaries, so I want to get benefits, even though the trust is now completely different, run by different people, has different beneficiaries. So we strongly suggest against amending trust deeds to that degree because it doesn't make sense. It leaves a lot of open doors. Buying a property directly is probably the easiest way of doing it. And under most circumstances, given the opportunity and paying the same price, I'd probably go for the asset over the shares because there's really no benefit going for the shares unless the shares you're buying is in a business that has very good goodwill, that has reputation, that has brand, that has all these things, in which case you're buying a business, not a property. So don't look at it as just a property. You need to assess whether buying the business is of value. But yeah, so that's the
short version.
Yeah.
I think it's important to mention, I mean, as of now, the transfer duty threshold hopped up with another 100,000, so 1.1 million is the threshold for transfer duty. So if you're buying a property under 1.1 million, you're obviously not paying transfer duty. Please remember, guys, if you're not paying transfer duty, you're still paying transfer costs, the ones to SARS, the other ones to the conveyancer. But I mean, you can buy something for 1.1 million that makes a lot of sense, and you're still staying under this threshold. But
Exactly.
I mean, chances of buying a massive commercial property for that value is a little low. But and please remember, if you buy a property and you're trying to stay under the transfer duty threshold, do not change the purchase price to stay under 1.1 and then do an AOD for the rest. That is called tax fraud, and nobody really looks good in orange.